So I'm Jim Cunningham. Today we're going to talk about how can successor trustees get paid? What are reasonable trust fees? This is a very, very common question that comes up. And for many people, they say, look, I've been named successor trustee. And do I get paid for this or not? If I do, how much do I get paid? Do I get paid a percentage? Do I get paid in some other method? Is there some other methodology? We're going to cover all of that today in this video. So how can you get paid? Well, trustees are entitled to what is called reasonable compensation, a reasonable amount of money. We're going to talk about what that is because that's something that is common throughout the law, and unfortunately is not necessarily well defined in the law, and it is county by county, and we'll cover that. But is it an hourly rate? Is it a fixed rate? Is it a percentage or a performance-based? You know, who decides? Does the trustee decide? Does a court decide? Well, it depends. You know, we're going to go over the rules. We're talking here today primarily about individual trustees, not so much the corporate trustees, because they tend to have their own trustee fee schedule, and private professional fiduciaries are typically governed by the same law, but they're treated slightly differently, okay? And typically those fees are, frankly, they tend to be higher than individual trustees serving. We're going to talk about this within the context of the living trust. So we're not going to talk so much about irrevocable trusts or GRATs or IDGITs or all these other types of trust. What here we're talking about is someone who sets up a living trust and that person passes away, and then somebody else comes in and they have to take care of things, right? Wind up the deceased person's affairs and distribute assets. We are not talking about bankruptcy trustee fees. So if you try to Google this or you go out on the ether or, you know, AI or whatever it is, and you talk about trustee fees, bankruptcy trustee fees are in there. That is something totally different than what we're talking about today. So that's something that we're not going to be discussing. So I'm Jim Cunningham. I'm a partner at CunninghamLegal. I have almost 30 years experience. We do have offices throughout California, Northern and Southern California. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities, and insurance licensed, also a pilot. We have attorneys in our firm. I think it's 12 or 13. I can't, I don't really know. And we have one more here starting in just a couple of weeks. So we handle all things estate planning, trust, probate, real estate for our higher net worth clients, basically. So people who can afford to hire an attorney, right? They reach out to attorneys like us, and then we help them with those matters. Go ahead, if you're watching this on YouTube, and again, this is put on YouTube, this content's put on YouTube, you can go ahead and subscribe to our YouTube channel, and it keeps you up to date, right? And if you click the little bell, it'll pop up in your feed, and so you'll be sure to catch our content, which is typically released weekly. I'm a lawyer. My lips are moving. Words are coming out of my mouth. I'm talking. This absolutely is not legal advice, should not be taken as legal advice. On this one, we're going to cover a lot of law today. And really, I'm kind of reciting what we call the black letter law. So the law as it's written in the code books, and we're going to be going over that, right? And the local court rules. So, but again, this is not legal advice. Before we talk about trustee fees, we really need to ask ourselves, what is a successor trustee of a living trust, and why and how are they paid? And what I mean by a future trustee. So if you've set up your own living trust, you're the trustee. And when you set this up with your lawyer, which I hope you did, you set this up with your lawyer might ask you a question like this. Well, who would you like as your successor trustee? And you're like, I don't know what that is. That's the person who steps in when you stop being trustee. So we all stop being trustee of our own trust. We can't live forever. And that's what we're talking about here is the successor trustee. By the way, once you start serving as trustee, you are no longer called successor trustee. You are called trustee. And if there's two, then you'd be co-trustee. And but that term successor trustee means someone who is named, but may or may not serve in the future. If they're not alive or they don't consent to serve, then they're not going to be trustee. So what is a trust? Very quickly, a trust is like a bucket with a handle. And into this bucket, you put all your assets, your stocks, your bonds, your mutual funds. That handle is held by a trustee. If this is your living trust, you're probably the trustee. And then when you stop being the trustee, that bucket passes to the successor trustee. And again, that's the person who is named as successor trustee. They're nominated. And then when you stop serving as trustee, your successor trustee then becomes the trustee and drops the successor title. So when we talk about successor trustee, we're talking about somebody in the future who's not yet serving as trustee, somebody that may or may not serve in the future. And that's really what we're talking about here. The thing about living trusts is they are private, and living trusts are designed to avoid probate court. They can, however, be pulled into probate court. Now, what do I mean by that? Well, we're going to talk a lot about this, that the probate court in California has the right to make decisions over property that's in a trust, so long as that trustee is a California resident. And we'll talk about that. So another benefit of a living trust, if it's written properly, it can provide no creditor protection for an inheritance or divorce protection for an inheritance, or that living trust can provide inheritance. So a protection for that inheritance. So if you have an estate plan, or maybe you're going to inherit from your parents, let's say, and you're like, gee, I don't know if I really want to share that with my spouse, or I'm worried I might get a divorce. There are things that the parents can do for the kids, not so much that the kids can do for themselves, but really the parents can do for the kids in this situation to protect that inheritance, that future inheritance from divorce, right? So you can maintain its separate property character, and we'll talk a little bit about that. Trusts are for beneficiaries, okay? Probate is for creditors. This is very, very important to understand. So I think lawyers miss this. And this is one benefit about being a certified specialist. I actually taught a continuing education course specifically about creditor rights in a living trust administration. And it's very important to understand, trusts are created for the benefit of beneficiaries. Trusts are not created to pay your creditors when you die. Now, that living trust may ultimately be responsible for your debts. This is not an asset protection strategy to do a living trust and avoid paying the debts, but the basic framework, the structural framework of a trust, is that it's designed primarily for the benefit of beneficiaries, the people who inherit, the bene, the people who get the goods. Probate, on the other hand, is really designed to pay your creditors. So some people have described probate as a lawsuit you file against yourself to protect your creditors, and to a large extent, that's true. The probate process is there, not so much for the heirs, the people that inherit, but it's designed, its very essence and its design is to pay creditors. The rules on creditors when it comes to living trust versus probate are different, and the rules favor creditors in the probate context. So what is a successor trustee, right? We talked about this. Hint, this is not you, right? You're not going to be your own successor trustee because you'll be dead, you'll be incapacitated, you'll resign, whatever it is, it's going to be somebody else. Again, this is the person who handles the day-to-day affairs of the trust. That person holds, administers, and distributes the trust asset. And when I say human, I mean a human being with a heartbeat, someone who's alive. If you're dead, you can't be trustee. Kind of Captain Obvious stuff, but you have to have your heart beating. You have to be over the age of 18. You cannot be incarcerated. There's some basic rules there. And that successor trustee carries out the terms of the trust. Even if you name a bank, even if you name or some other organization to serve as your trustee, there will be a human being that is designated to sign on behalf of the trust. So these things don't self-execute. They don't, this paperwork doesn't handle stuff on its own. There's a human being involved. And so a trustee has a lot of responsibilities. The trust has to follow the terms of the trust as written. And this is really critical. So this is a little bit different between a trust and a power of attorney, like a durable power of attorney for healthcare. A living trust, that successor trustee must follow the terms of the trust as written. The trustee cannot deviate. Now, the trustee does have some discretion in certain contexts, but must follow the basic terms of the trust as written. The trustee also has to follow applicable statutes, case law, doctrine, local rules. There are local rules, and we're going to get into that in a few minutes. And the trustee has to manage the assets and the other investments and communicate with the beneficiaries. These are the people who are inheriting, as well as other people. And trustee services, the trustee can be paid for these, but sometimes isn't allowed to be paid, or maybe shouldn't. And we'll cover why it may be a good idea not to take a fee in certain cases, believe it or not. And it has to do with taxes. So there's a lot of responsibilities that a successor trustee, that the person who is serving as trustee, has. Why do people stop serving as trustee? Why would I ever stop serving as trustee? Well, I could resign. Maybe I say, hey, I'm gonna go to Antarctica for 6 months or something, and I'm out of communication. Well, I might need to resign and appoint somebody else. I might be removed, right? If I'm a successor trustee and somebody doesn't like what I'm doing and they go to court and they get an order, I can be removed as trustee. Also, a trust protector can remove someone as trustee. We'll talk about that a little bit. And also incapacity. So if I become incapacitated, I can't serve. And certainly if I pass away, my heart is not beating, I can't serve. And each of these methods triggers a slightly different consequence. So it's very important to understand the nuance. So if a person is a trustee and not the sole beneficiary, so if I become incapacitated and my son serves as successor trustee, there's no duty to account to his siblings, his sisters, but there will be in the future. Okay. So when I die, he's going to have to account potentially on demand to his sisters. So that's a Geraldine case. That's kind of a California thing. I think it's generally true in the rest of the country. So there are some things that you have to do. And even if a trustee dies, there's still a duty for that trustee to account. And that's typically the trustee's executor. So if I die, it would be the executor of my estate. Or if my son dies, it would be the executor of his estate would have a duty to account to his sisters. I'm going to go through 6 months of law school of one course in about two or three slides. So you're going to get a quick dose of civil procedure. It's very important to understand this as a foundation before we can even talk about fees, because the trust gives the trustee a lot of discretion, but ultimately the probate court is the police officer that ultimately can sort things out, okay? The probate court has ultimate authority over the trust, not the trustee. So it's very important to understand. Trustee can act, and if somebody doesn't like it, they can take the trustee to court. So there are two concepts we need to unpack here. One is jurisdiction. That's from Latin, juris meaning law, and dictio meaning saying. So this is the law saying or judge saying. There are two, so the courts can make a ruling with respect to people, right? Can a court rule with respect to people? And then can a court rule on this particular subject? Okay, so a couple of things. Personal jurisdiction, can the court rule? Can the court make an order with respect to the trustee? So if I'm serving as trustee for somebody's trust in California, which we don't do, by the way, so it's a bad example, but our firm, we don't serve as trustee. Does the court have jurisdiction over trustees in California? So the law says if you are a California resident, the trust has automatic jurisdiction over the trustee. Nobody has to sue you, or nobody has to, file some type of lawsuit and a subpoena if this concerns the internal affairs of a trust. So it's very, very important to understand, if a trustee's doing something bad, the beneficiary can go straight to court, and the court already has jurisdiction over the trustee under law. So there's no serving a summons or a complaint or anything like that when it comes to the internal affairs of a trust. Subject matter jurisdiction. So can the court rule against this particular person? So I've never been to Montana. I have no connection with Montana. A Montana court cannot make an order with respect to me. There's no connection. There's no nexus. Okay. So that's kind of the idea behind it. Subject matter jurisdiction. Does the court have the authority to rule with respect to this certain type of matter? It's very important to understand that trusts in California are dealt with only in the probate court. So when we talk about the internal affairs of a trust, not necessarily a trust is owed money and they're suing people, right, to collect the money. But this is on the internal affairs, which goes to compensation of a trustee, right? So if a trustee takes compensation and a beneficiary doesn't like it, and they say, you know what, I think you're taking too much compensation, that beneficiary would file in the appropriate probate court, and that probate court has subject matter jurisdiction. That probate court is the only court that can hear that matter, and the court has jurisdiction over the trustee, and so the court can make a rule that binds the trustee. So it's very, very important to understand, because this, I'm going to tee this up as it relates to fees. Then there is venue. Now, when I say venue, if you go to a Taylor Swift concert, what is the concert venue, right? Right? Levi Stadium, Santa Clara. That's the place. The venue is the place where the thing is happening. So can the court rule against an individual? Can the court rule with respect to the internal affairs of a trust? Yes and yes. The next question is, which court of 58 counties do you file in California? And so we have an example here. The answer, by the way, is the county of the principal place of administration is the proper venue. So this is if somebody has a problem with the trustee doing something, that beneficiary would file. The proper county to file in is that county in which the day-to-day activities of the trust are being carried out. So, for example, mom dies a resident of Los Angeles. Sonny, who's the son, lives and works in San Francisco. Now, Sonny's a trustee. So when daughter files a lawsuit against Sonny saying, hey, Sonny, you're not doing your job as a trustee, or I don't agree with your compensation. Even though daughter's a San Diego resident, she has to file in San Francisco because Sonny's a San Francisco resident. Okay, so 3 different counties. Which county do you file in? You just can't pick any county you want to pick, right? There are rules on this, and that's venue, where you can file the action. This is highly relevant when it comes to fees, as you will see, because it gets county by county by county, right? And there are 58 counties. We're not going to go through 58 examples, and you'll see why. Now, if the principal place of trust administration can't be determined based on the day-to-day activity, maybe a person works in one county and lives in another. If it has a single trustee, it's typically that trustee's residence or usual place of business. If there's more than one trustee, maybe co-trustees, it's going to be one of those people's location. And it's very important, just because the court has personal jurisdiction over the trustee, which all courts in California, all courts, all probate courts have personal jurisdiction over all California resident trustees. And just because the court has subject matter jurisdiction does not mean the court can or will hear a case if venue is improper, meaning if that place where that matter's heard, if that's not the correct place to hear that matter. Again, highly relevant when it comes to fees. There's also the concept of a trust protector. So this is something very important to understand. A probate court has the power to change the terms of a trust to conform to the intent when you're gone. So let's say, and we have an example that follows here, the trust protector has a similar power. Now, this is not you because you're dead. It's not your trustee. It's not your family members. It's not siblings. Typically, it's the lawyer or the law firm that drafted the estate plan. And the idea here is that there's an independent third party that if something is obvious and everyone agrees, remember the trustee has to follow the terms of the trust. If for some reason the terms as written do not conform with your intent, the trust protector can change those provisions. And this keeps it out of probate court. And you want to stay out of probate court for many, many reasons. But one of the problems is once you initiate an action in probate court to do something with respect to a trust, it opens up a forum or a place where a disgruntled beneficiary, if they don't have the money to hire a lawyer, right? They don't have the $10,000 or whatever it is to bring a trust petition, and you're in court, that person can come in and say, Your Honor, you know what? There's this is going on, that's going on. I don't like this. Maybe it's someone who's just kind of a stick in the mud. And it gives them a venue or a forum where they can come in and cause problems for the trustee. So an example, Hal creates a living trust that leaves 123 B Street to Sonny. But after this, so 123 B Street, everyone agrees, Sonny gets that, and maybe he's living there. But after the trust is signed, Hal sells 123 B Street and buys 456 C Street, right? Maybe a few blocks away. Now, Hal dies thinking Sonny will get 456 C Street because maybe it's the house that Sonny's living in, right? Maybe Dad bought him a house and then sold that house and bought another one, and everyone agrees that Sonny should be getting that house. Well, because the trustee must follow the terms of the trust, that gift is deemed, meaning it goes away, right? So if we say, hey, Sonny, you're going to get 123 B Street and Dad doesn't own it when Dad dies, that's a real problem because now Sonny's not going to, he's not going to get his house. So the trust protector can meet with everyone and say, look, obviously this is what the intent was. So we're going to rewrite this provision. And instead of it saying 123 B Street, we're going to say it's 456 C Street. Everyone agrees, everyone's happy, keeps it out of court, saves the estate probably $15,000, quite frankly. So these are not inexpensive endeavors. That's a trust protector. Now, probably what you've been waiting for. What is a reasonable amount of trustee compensation? Okay. How do trustees know what to pay themselves? Now, sometimes a trust will say, the trustee shall get 1%. The trustee shall get 0.5%. All right. Sometimes it's in there. Many times it's not. Many times it says reasonable compensation. Well, again, is it a percentage? Is it based on effort, time spent, performance? What if a person does a really bad job that costs the trust, some money and really costs the beneficiaries? Should they be paid for that, right? Ultimately, the probate court has jurisdiction, meaning the probate court is the ultimate arbiter. The first arbiter, the first decider, is the trustee. So the trustee says, look, it's reasonable compensation. I think 100,000 is reasonable compensation. I'm taking 100,000. If somebody doesn't like it, that if a beneficiary doesn't like it, meaning someone who inherits, they can take that trustee to court. And this is why it's really important to understand this jurisdiction, this venue, and the different counties, because it depends on what county you're in, because the rules are different county to county. But again, a probate court will rule on the ultimate reasonableness of fees. The concept of reasonableness is a is the product of Western civilization. It's American, it's British, it's European. It's kind of throughout Western civilization, this concept of reasonableness. And it's kind of like you know it when you see it. This goes way back to Roman times. It's in medieval law. This comes from the canon law or the church law. Probate courts deal with affairs of the soul, death, trusts, wills. And that was typically the purview of the church court. So back in the Middle Ages, when the Catholic Church was kind of the church in Western Europe, that church had canonical courts, and those people would deal with affairs of the soul. So you would not go to a law court, a court under the supervision of the king. If you were dealing with a will, it would be a church court. So this is really important to understand, because law courts follow the law, and these equitable courts, and you can think of, equity, and that's a lot in our popular culture now, like DEI, diversity, equity, inclusion. What does that mean? That means fairness, okay? This has been around for 2,000 years in our society, in Western civilization. Fair is proper or moderate under the circumstances. Now, fair is a four-letter F word, right? It is the bane of trust interpretation. I will tell you, as a trust lawyer, when I see pay a reasonable fee, I kind of scratch my head. The clients scratch their head. What do? We have to work through it. And you'll see as we go through the materials what this working through looks like. But it is frequently the purview of litigation. Let's say a trustee says, hey, I think on this trust, a reasonable fee is $100,000. And a beneficiary disagrees. Well, the beneficiary takes that trustee to court. And then then the court ultimately decides what's reasonable and what's not. So fair is what is objectively sensible, and not based on mere caprice or whim or personal prejudice, but sensible to whom? It is sensible to the probate judge ultimately. So that is the ultimate person that we're thinking of as practitioners, as lawyers. So law is an applied practice, meaning there's theory, there's law, there's rules, there are factual situations, and we apply those laws and rules to a given situation. So you may see similar fact patterns, right? You may see similar trusts, and you go, well, this one fee was $50,000 and the other one was $100,000. Yes, because there are different facts that distinguish those cases. And really that's where the lawyering comes in. So this objective reasonableness test permits the bench officer, which is a judge. Lawyers refer to judges oftentimes as bench officers, to look at the facts and do justice as the probate court sees fit, right? Now, this certainly will be justice for one person, but not to the losing party, right? So, and maybe even to the winning party. They say, I wanted 100 and I got 50, I'm disappointed. And the person who says that person got 50, they should have gotten nothing. So no one's happy. So I will say though, if you're a trustee and someone's threatening to sue for whatever reason, right? A beneficiary, they typically, this is kind of one of those things that you kind of throw in, right? You throw everything in the kitchen sink in, you're going to attack the reasonableness of the fees, right? Which is, can be a slap in the face to the trustee, whatever it is. I mean, a figurative slap in the face, but they're typically going to see a challenge to fees. And this is, there's a trend in law to have mediation. So there's litigation and judgment, which is where a judge rules. There's arbitration, which is where a private judge, translation, very expensive, because you got to pay the private judge. So it's very expensive kind of private court proceeding is arbitration. Then there's mediation, where you sit down with typically a retired judge. It's also expensive. And you resolve, you come to an agreement where all parties are kind of unhappy, but they come to a resolution that is acceptable to all the parties, versus having to go to court and really having no say in the outcome. So that's a trend in trust and estate litigation. So under California law, there are 8 factors to consider when determining trustee fees. This is straight out of the California probate code. What is the gross income of the trust estate, right? How much income is coming in, okay? Success or failure of the trust administration. Did the person do a good job or a bad job? If the trustee did a bad job, that's going to negatively affect compensation. Were there any sort of like unusual skill, expertise, or any experience of value add that was brought to the trustee's work? If it's a CPA who's a successor trustee, they're bringing skill or expertise, and those are skills that can be very helpful. It's case specific. Fidelity versus disloyalty by the trustee. Was the trustee loyal to the trust assets and to the beneficiary? So we cover this a lot in other webinars, which is trustee duties. A trustee has a duty to the trust itself as well as the beneficiaries. So if they show disloyalty to the beneficiaries, if they sell themselves assets for less than market value, without full disclosure and consent, those are things that would be a disloyal act, right? Is the amount of risk and responsibility, what is the amount of risk and responsibility assumed by the trustees? So for risk, there's reward. If they're taking a little bit more risk and it works out favorably, I suppose, then that factors into fees. Time spent, I'll say this is probably the biggest factor, time spent in the performance of the trustee's duties, time spent, and then your skill and expertise. Those are probably the two biggest needle moving factors. So time spent, what does this mean? If you're a trustee, I would strongly suggest you track your time. So met with the attorney, hour and a half, got all the financial statements together, met with the CPA, 8 hours, whatever it is. Track your time, because you'll see as we go through in the local rules, sometimes this is time-based and you will get an amount per hour for time worked. So it's very important to track your time. I know, look, even lawyers don't like to track their time, and we have to do this professionally. And if you're thinking like, man, I really don't want to be a successor trustee, you're not alone, because a lot of people, they don't want to be a successor trustee. The custom in the community where the court is located, very important, in the county where the court is located, and potentially even the particular judge in the particular county, and that would be the local custom, and whether the work performed was routine or required more than ordinary skill or judgment. And we have a couple of examples here. So mom dies in a healthcare facility and has $100,000 in the bank and no creditors. So daughter's trustee fees will be on the lower side because there's not much to do. There's no real estate. There's not a lot going on. On the other hand, dad, a practicing physician, dies suddenly, and Sonny has to close dad's medical practice, deal with multiple rental properties, 2 vacation homes, one's in Cabo in Mexico, right? Deal with the creditors, collect accounts receivable from the medical practice, file multiple income tax returns, make timely tax elections in dad's trust, pay death taxes, and hold and administer and distribute assets for the benefit of himself and his disabled sister. You can see that's an example where the fees would tend to be higher. And so what the example, the reason I'm raising these two kind of contrasting examples is not all trust administrations are the same. There's a lot of stuff that must be done in both of these. But in weighing the factors, in figuring out, gee, what should the compensation be, the more complexity, typically the more compensation. Now, when can you take a fee and when should you take a fee? So I would say you should be paying attention to tax years. And a lot of times a trust or an estate, a probate estate, will end in December. That'll be the end of the tax year. And some that correlates with the personal, the 1040 returns. There are a lot of reasons why you might want to do that. But distributable net income is a very important concept. So distributable net income means what you're talking about is income after expenses, and can this be distributed? So trusts, it's very important to understand, trusts are taxed at significantly higher rates federally, okay? Big deal federally, right? Significantly higher effective tax rates. What I mean by effective tax rate is you get a little bit over $10,000 in income on a trust, you're paying tax at the federal 37% level. So it might make sense, and we do have an example on this, it might make sense if you have a trust administration that lasts 15 months, pay attention to when you should be paying trustee fees, because you may want to pay them in a year where you have significant income, because otherwise it's going out to the door in taxes, and nobody wants that. You know, even your jerk brother who's causing you problems, even the jerk brother doesn't want you to pay more tax. So when can you not take a fee? Sometimes a trust will say, if a family member is serving as trustee, then there's no fee allowed. Now, I've seen that. Personally, I think that's a little kind of restrictive. I think you would always want to kind of reserve the right to take a fee for whatever reason, but sometimes it won't prevent, sometimes it will preclude or prevent you taking a fee if it's a family member serving. Now, there's another one, which is, you may not really think about this, but if you're the sole beneficiary and you take a fee, you might be shooting yourself in the foot. Because if you take that $100,000 fee, that's income. You're going to have to pay $100,000 in income taxes. You might as well just take the $100,000 and not pay any income tax, right? So I think this is where it makes sense to talk to your CPA, your attorney, your financial advisor, kind of forecasting on what your taxes are going to be, and you kind of adjust the dials and you throttle the timing of the payment of fees for maximizing the tax deduction. So little kind of an important aspect of timing. So an example here, mom dies in January 2023 with a living trust that has $1 million in a money market paying 4%. Thank goodness interest rates are up for those of you who have savings. You know, that's really a benefit for a lot of people. So that's about $40,000 in income. Now, mom's trust is finally settled at the end of March in 2024, and then there's another $10,000 in income from the money market. Now, there is this 65-day window. So if you're CPA watching this or an attorney, you'll be like, Jim, wait about what 65-day window? That means if they had wound the trust up within 65 days of the end of the tax year, which is December 31, you can sort of relate back to the prior tax year. And the government gives you a little bit of grace, believe it or not, a little bit of a break, and as long as that activity happens within that 65-day window. So it makes sense in this case for the trustee to pay expenses like trustee fees, okay, for example, in 2023 and not wait till 2024, because the income taxes on $40,000 in income in a trust federally are $15,000. That's a lot of money. Now, if that trustee fee were $40,000, then the trust would not be bearing that income tax liability. So it really saves the trust $15,000. So we're doing this a lot at the end of the year in our firm as we're kind of looking at what the income is. Now that interest rates have come up and people are actually getting a return on savings, it's becoming more of an issue in our practice. But this is one of the things we do pay attention to. You know, how do we pay less money in tax? Because really it's going to the beneficiaries. That's why you have a trust, to benefit your beneficiaries. So again, the timing of the payment of trust expenses can affect the overall tax bill. So what you've all been waiting for, how much can you get as a fee? Venue, the county in California matters. Now, you might be thinking, you got to be kidding me, Jim. This is so complicated. I want to pull my hair out. You're not alone. There's a lot of people look at this and they go, wow, this is a real pain in the neck. If the trust, it does not specify the trustee's compensation, and I will say many trusts do not specify, there are arguments in favor of specifying compensation and against specifying compensation. We have kind of a hybrid approach in our firm. In many estate plans, we'll include a provision that says if it's 75% of the probate statutory fee for settling the estate, it is deemed reasonable, right? The grantor says this is reasonable. The reason we do that, I really don't like the fee disputes over, or the fights over fee disputes. I think those are oftentimes, those disputes come from something other than the fees themselves. I think it comes from animosity between siblings. You know, it's like Sally got the red bike in 1962 and I'm still mad. And so I'm going to do everything I can to be a jerk and get back at Sally. So we're trying in our practice, we're trying to remove that as a weapon, you know, sort of to de-weaponize as much as we can the issue of fees. But again, if the trust does not specify, if the trust says it's reasonable, there are 58 counties in California, 43, which covers 2/3 of the population of California, have no local rules. So when I talked about the 8 attributes of trustee fees, those are the attributes a court's going to look at. 15 counties of the 58 have what we call local rules. So these are rules that apply in that particular county, large and small. Some counties by population, some are very large and some are very small in California. And that gives you guidance on trustee fees, and that covers about 1/3 of the population. But I would say as sort of this insider tip, in all circumstances, if you're serving as trustee, it is a really good idea to document your efforts, to document your time, to keep a journal. On this day, I spent 3 hours doing this activity. I cleaned out, you know, mom's garage. It took 3 days. You're going to get less money for that per hour than if you're meeting with the CPA. Okay. So I've seen some judges say, look, we'll give you a lesser amount if it's, you know, more kind of physical manual labor, and more if it's this other type of labor. So these are things you can talk about with your lawyer. And if you don't have a lawyer, certainly reach out to us and we can certainly help you with this. But it's very important to understand that I would say just if you walk away with one thing today, know that it's vague when it comes to fees, and it's really good to document your time because that can really help you when it comes time to get your fees. So let's talk about what is the proper venue. So you'll recall that the proper venue is where the day-to-day activities of the trust occur. And typically it's going to be where the trustee resides. And oftentimes those are the same thing. So let's say mom dies a resident of Los Angeles County with a $10 million estate. Mom's trust owns property in Placer County. Now, for those of you who don't know it, it's not Placer County, it's Placer County. That happens to be North Lake Tahoe. and that happens to be the second highest per capita wealth on a county basis, like per capita county, but second wealthiest county in California. That surprises a lot of people because there are a lot of properties in North Lake Tahoe that are very nice properties. Daughter is a trustee and a resident of Marin County, which is just north of San Francisco. Sonny's a resident of San Diego. So we got mom in LA, the home's in Lake Tahoe and Placer County, daughter's in Marin County, and she's a trustee, and Sonny is in San Diego County. The daughter, when she's administering mom's trust, she says, 10 million bucks. There was a lot going on. We had a lot to do. I think a 100,000, which happens to be 1%, is a reasonable trustee fee. That's how the math works out. So the daughter, she does all this work, winding up her mom's affairs, and then splits everything 50-50 with Sonny. Sonny says, you know what, daughter, I don't, you know what, you got that red bike in 1962. This is what he's thinking in his mind. Hopefully he doesn't tell his lawyer that, because the lawyer would be like, come on, guy, you know, if that's your reason, that's not a good reason, right? But I'm going to sue her. I think 100,000 is too much. I think it should have been less. So he files in Marin County. Marin County is the proper county, not where the property is located, not where he's located, not where mom was a resident of, but the county of the principal place of trust administration, which in this case happens to be Marin County. Now, it just so happens that Marin County is one of the 58 counties where they have local rules. Now, in Marin County, if the daughter is not a corporate trustee, in Marin County, this daughter happens not to be a corporate trustee. And so the Marin County guidelines, they say it's an amount not to exceed 0.8%, which is 0.8% of the principal of the trust per year per annum. And that's the carry value. So that's sort of the book value. It might be date of death value, and you kind of carry that forward. Whatever's on the books, even though the property may go up or down in value, it's whatever's on the books. They say, you know what? And, you know, that just, that's what the fee is, right? Now, the daughter as an individual is not entitled necessarily to that. She's entitled to get payment on a quantum meruit basis. Quantum meruit, Latin word, which is value of the services rendered. So this is a reasonable sum for services rendered when the amount is not stipulated in the trust. There's a companion one, quantum valibat, which is if there's nothing stated in the trust, but there's a trust and all trusts are written. So, well, not all, but in this case, it's written. And this trust is what Marin County says is if you're serving as trustee, basically track your time and we'll take a look at it. And so I would say generally these fees, what we see on an estate of this size, they're generally coming in 0.5% to 1%. Just in our experience, by the time you go through everything and all the stuff you need to do. Now, the question is, if daughter, let's say daughter is going to take a $100,000 fee, but should she even take the fee at all? Because if she takes a fee of 100,000, let's say she's making money, and she might be taxed at 50%. It might be better because if she takes a $100,000 fee and has to pay 50% in taxes, she's getting 50,000, right? If she takes no fee, her brother's going to get an extra 50. She's going to get an extra 50. It may be the same thing. So where I'm going with this is just because you can take a fee doesn't mean you should. And you really need to run the after-tax calculation on this. And I will say generally what we see is courts are allowing $30 to $75 an hour for you to be a trustee. It's going to be higher if it's a private professional fiduciary, but for non-professional fiduciaries, that's what we're seeing. So 43 counties here, if you're watching this on YouTube, there's a list of the 43 counties here that do not have local rules. Los Angeles is a county that believe it or not, does not have local rules. Now, the real story about this is the California rules of court are basically the local rules of LA, because LA is 1/3 of the population, but they're one of the 43 counties that doesn't. 15 counties, Calaveras, Contra Costa, Kern, Marin, Monterey, Napa, Sacramento, San Diego, San Francisco, San Joaquin, San Mateo, Santa Clara, Santa Cruz, Solano County, and Tulare County all have local rules, and most of those are in Northern California. So let's look at Calaveras County. We'll just take these, we'll go through these quickly. Calaveras County, whopping population of 46,563. What are their rules? Well, if you're going to ask for fees, so again, the context is if you're a trustee, you can say, I think a reasonable fee is $10,000. If you take that and nobody objects, you're good to go. But if somebody objects, and really this is the answer to how much can I take or how much should I take as a trustee, the lawyer's going to say, look, if you're a resident of Calaveras County, then you really should be looking at the local rules, because if there's a problem, then you're going to go to court and you're going to have to justify these fees before the probate court, because the probate court is the ultimate arbiter of those fees. So you bring your petition for compensation, right? So if somebody objects, they say, I don't think this person should get any compensation. You're going to have to, as trustee, you should file a court filing that says, yes, I want to be paid, and this is how much, and this is why. It's an itemized statement of the services rendered, an explanation of the value or the benefit those services were to the estate, and the total amount requested. And it has to be under penalty of perjury, which says, you know, I raise my right hand and I swear it's true. And the court then evaluates the petition for just and reasonable, right? They have to be both just and reasonable. Again, this goes back to the church courts, that this is not a court of law. They're not looking at, oh, it's not robotic. You did 100 hours and it's $50 an hour, so you're going to get 5,000. They go, well, was it just? Was it reasonable? Did you take too long? Are you charging too much? I might cut your hourly. I might say, you know, I don't think it should have taken 5 hours to do that. I think it should have taken 3. I mean, this is real world stuff we see with judges. They really get granular and they say, no, no, no. And then, so you're going to look at the just and reasonable compensation according to the services performed, time expended, average hourly rate, results accomplished, and the benefit to the trust estate. Very important. If your activities aren't benefiting the trust estate, you just might not get paid. Contra Costa, East Bay, Northern California. The petition for approval of prospective or previously paid compensation is really important. So if you pay yourself compensation as trustee and somebody says, you know, a couple of years later, I don't like it. If you're a trustee and you have not gone in and gotten a court approval of your accounting, you may have to prove up your time a couple of years later. It's really important you can see why it's important to document it. So you want to write it down as you're doing it, because you don't want to have to remember stuff you did 2, 3, or 4 years ago. But again, California, they're under the California Rules of Court 7.776, which is basically recites the California statutory. So their local rule is kind of not really a local rule. And then Kern County. It's ordinarily allowed as provided in the trust, unless the court fixes a greater or lesser amount. So if the trustee compensation is 10% of the trust estate, a court might go, you know, that's ridiculous. We're going to knock a 0 off. We're going to make it a 1. Okay, so they do have the power to reduce it. But if the trust is not specific, the Kern County Court will establish reasonable compensation. A lot of times in Kern County, it'll be 1% of the fair market value of the assets, but it's prorated. You know, if the trust administration took 6 months or 9 months, it's not going to be the full percent. And if it's higher than 1%, if the amount asked is higher than 1%, that request must be supported by detailed description. Again, description of the services rendered, the necessity, the benefit to the estate, the expertise required, the time expended, and the hourly rate. So I hope you're starting to see a pattern. You need to keep track of your time. You need to say what you did. You need to say what, you know, specialty expertise was required, because this is a common thread in each county. Monterey County, as a general guideline, we're seeing 0.75%, which is 0.75% of the fair market value per year. A court approval, if the trust is under the continuing jurisdiction of the court, meaning someone has filed complaints about the fee or some other things going on at the court, then in all instances, the trustee has to get court approval. So you're going to have to go through that similar proving up of the time and the amount and the benefit to the estate. So Monterey County is following that state rule. Napa County typically is about 1%. You can see all these counties, what, 0.8, 0.75, 1%. Yeah, you're starting to see a range. And in Napa County, a court will entertain a request for a higher rate, again, with a description of the extraordinary services. So something that went above and beyond the things that a trustee normally does. Look, if it took more time, we'll entertain that. You might not necessarily get it, but you'll have a hearing and we'll listen. San Francisco County, generally based upon 1% per year of the fair market value of the assets or 6% of the income, again, in the court's discretion. Now, you might be thinking 6% of income, that's not very much. But many times you will have an intangible, a patent, a royalty. You might have a personality, or someone who's getting residual payments, whatever it might be. Then that 6% of income, because sometimes it's hard to value an oil interest or something. Then you're getting that residual income coming in, and so it's kind of an either or, one or the other. San Joaquin County, population 793,000, so kind of a medium-sized county in California. In the absence of a formula for trust fees in the trust document, the trustee compensation is presumed reasonable if it's not more than 1%, and or 0.75% for a non-professional. So professional 1%, non-professional gets less. Why? I don't know. I don't write the rules, right? But nothing limits the court to even if you take 3/4, it doesn't limit the court to say, you know what, that's too much. We're going to cut it even further. Okay. San Mateo County, large county, wealthier county, Peninsula County. In determining compensation of a trustee, the court consider additional factors in addition to the factors, the 8 that we discussed. One is whether the trustee has delegated work to others. Very important. It's very interesting. Did you hire a bunch of people to do stuff for you, or did you do it yourself? Are you the trustee and did you hire a private professional fiduciary, right? So if the trust says you get it 1% and you hire a private professional fiduciary and say, look, I'll just pay you 0.5%, and you take the spread, a court in San Mateo County, they're going to look at that. If the trustee is a corporate trustee, the published rates for its usual services, and if it's a private professional fiduciary, the usual hourly rate. We cover that in other webinars, but basically all the corporate trustees will publish their rates. You can Google whatever trust bank, they're going to say what their rates are, and it's based on a percentage of assets, typically higher than private professional fiduciaries, and private professional fiduciaries are typically higher than individuals. So there's a hierarchy there. Whether the trust assets are being administered as a passive activity or require active management. Passive activity would be $10 million portfolio of investment securities, stocks and bonds. Active management would be a business that's worth 10 million, right? And you're in the day-to-day kind of working on it. So they're going to take a look at that in San Mateo County. And whether the duties of the trustee in administering the trust are similar to those of a personal representative of a pro-estate. And meaning what that means is this winding up the affairs of a decedent? So if it's it's a living trust and you're winding up the affairs of a decedent, and really the only difference is you have trust versus a will. And again, the will has that extra layer of court supervision. They're going to look at that as a factor as well. And then Santa Clara, population 1.8 million, so a larger county. If the trustee's compensation is designated in the will or trust instrument as being reasonable with no further guidance, the trust shall ordinarily be compensated on a quantum merit basis, meaning if the trust says reasonable compensation, again, we're going back to quantum merit. Remember, that's what we had in Marin County. And what that means is a reasonable sum of money for services when the amount is not stipulated in a legally enforceable contract. So the trust is a contract, fundamentally. It's a contract. It says reasonable fees. The court's going to look at quantum merit. They're going to look at the time spent. They're going to look at the benefit to the estate. They're going to look at all these factors. And that's why it's really important to document your time. And then Santa Cruz County. And the probate court generally allows a fee of 1% per year, generally. But court approval must be obtained in instances where the amount of compensation is not expressly authorized in the trust instrument. So meaning if somebody takes you to court and you maybe tell a beneficiary, look, I'm going to take $100,000 fee, and they say, I'm going to file something in court, you have to go to court to get paid. Okay. So if they file that in court, you're going to have to go to court. If no one's in court, you're going to take the fee. So this is only if the court has taken, has the matter open before them. Again, a mere recitation of a 1% guideline is not sufficient. And then we have Solano County, and the trustee compensation is presumed reasonable if it doesn't exceed 1%. So again, they're just saying, hey, 1% is fine. We're not going to put a lot of strings on that one. Tulare County, again, a medium-sized county in California, 477,000. That's a big population for a lot of states, by the way, or a lot of counties and states is 477. Yeah, it's kind of a medium size in California. The probate court determines just and reasonable compensation based on the information supplied to the court in the petition requesting the allowance of the fees or commissions. So again, the petitions has to explain how the fees or commissions are calculated. And we're going to talk about dates of service, the nature of the service rendered. We're going to talk about hours and fractions of hours. That's so lawyerly, fractions of hours. I spent 1 2/10 hours, not minutes, fractions of hours, go figure. Fractions of hours for services rendered, and the identity of the person rendering the services, like it was the trustee himself or herself versus somebody you hire, right? And the hourly rate charge for each service, each person rendering the service. So again, if they're different trustees, if you have co-trustees, one might be getting one fee and another might be getting another based on their time. So they're kind of dividing the job. But again, Tulare takes a different approach. So what are the minimum required successor trustee tasks? When I look at this and I look at all the things that a successor trustee has to do, a lot of people ask me, Jim, what is the bare minimum? right? And, we've talked about trustee compensation. And now let's talk about what are these sort of minimum tasks, because if you're getting paid, you're doing something if you're the trustee. This is just not an honorary thing where it's like, oh, I'm designating my oldest son as trustee and everything magically takes care of itself and he'll just get some fee and to be trust. No, you got to do something, right? Trustees have to do things. There's a lot of work. So these are the minimum required successor trustee tasks. This is the handoff. So mom and dad die. If you're the trustee, please get multiple death certificates. Don't get one. You're going to need multiple. Now, you will, in the real world, when you go to these different institutions, they need to see the original. They might give it back to you. If you record a document with a death certificate, that does come back to you months later. And, some other institutions may hold on to that death certificate. It just depends. But I would get plenty, right? Now, the trustee has to remove the prior trustee's name from all assets held in the trust. What do I mean by that? Well, if I am the trustee of my trust and I die, and my son is the successor trustee, I'm dead. I can't sign a document that says I've died. So my son goes to a lawyer, comes back to the firm, dad's firm, right? And we prepare a change of trustee for each property, meaning an affidavit of change of trustee, meaning Jim Cunningham's no longer trustee and Jim Cunningham's son is now the successor trustee, and his name goes on the title. And my name is also removed from the bank accounts, replaced by the successor trustee, who is now the trustee. So the named successor trustee, now the trustee. In California for many, many years now, more than 25 years, there is a statutory requirement to send notice to all the people who are named in the trust, as well as all the people who inherit in the absence of a trust. So all those people you might want to disinherit, you should be naming them in, if you want to disinherit a kid, we have a whole other webinar on this, whether you should or shouldn't do it and how to do it. You do have to name that child, and you do have to say that child gets nothing, because if you don't put that child in there, you have a big problem, because that may be deemed an omitted child. So all the people listed in the trust get a notice saying that they're entitled to a copy of the trust. And it identifies who made the trust, the date the trust was signed, who the current trustee is, or all the trustees' names, successor trustees. And then the trustee has to make an affirmative statement. Where's the principal place of trust administration? And you'll remember in some prior content, we talked about principal place of trust administration has a bearing on trustee compensation. So how you calculate trustee compensation. And then any additional information that may be expressly required from the trust. Now, we don't see that too often. And then that a statement that the person who's receiving this notice is entitled to a copy of the trust. Now, many times we'll send out a notice with a copy of the trust. Sometimes we won't. It just depends. This has to happen within 60 days of the trust becoming irrevocable. Newsflash, if you have a living trust, a revocable living trust, and you die, that's irrevocable. So if I have my own living trust, I'm the only grantor, I'm the only person who set up the trust, I die under California law, that's an irrevocable trust. So 60 days from the date of death, which is not that long. And this is something a trustee has to do. These are sort of the minimum mandatory things a trustee has to do. Is sent to everyone who would inherit in the absence of a trust, as well as anyone named in the trust, plus any prior amendments. Very important, a trustee should stop using the decedent's social security number. So if I die and my son is a successor trustee, he should not use my social security number. He would then complete a form SS4. Now, we handle that in our firm. Sometimes a CPA will do it. Sometimes clients will do it on their own. It's not a big deal to get, but you do need to get it. And that's something you get from the federal government, from the IRS. If I'm a property owner, which I am in California, the trustee must notify the county assessor's office within 150 days of death. Death is a change in ownership for real estate. Very important to understand. Property is reassessed when there is a change in ownership. So if my spouse does not inherit my property, let's say I don't have a spouse, but she dies before me, and then my kids inherit my property, that is a change in ownership. That's going to be deemed, that's a reassessable event. My kids might lose my Prop 13. In fact, they will, since Prop 19, right? They're losing that Prop 13. So if you don't file this timely, it can result in penalties. It's 10% penalty. If you have an LLC and control changes hands, or more than 50, or one person gets more than 50%, or in certain circumstances, more than 50% transfers, again, we cover this in other webinars, you got to notify the Board of Equalization. A lot of people don't know this. And if you don't notify the Board of Equalization timely, it's a penalty. So as long as it's not willful, there's a 5% cap on the homeowner's exemption. and 20% in terms of the penalty. By the way, if it's willful, it's just going to go back, years and years and years. So there is a reporting requirement. What should a successor trustee know? So if you are named a successor trustee, what are the basic things that you need to know? A trustee must act in the best interest of the beneficiaries and must not use their position for personal gain. Meaning, if a property is worth $1 million, you can't buy it for $100,000, right? You can't buy it for $900,000. That's called self-dealing. Okay, you're using those trust assets for personal gain. The trustee has to file any necessary tax returns, pay taxes that are due, and from the trust or K1 the beneficiaries. The trustee must make distributions to the beneficiaries as required by the trust, and the trustee is responsible for managing the assets. So it's a very tall order. The trustee must keep accurate records, and the funny thing is CPAs look at this and they go, this is the dumbest way to do it. Okay. But that's how you have to do it. That's just the law, right? Your CPA is going to say, well, it doesn't make sense to do it this way, but California requires trustees to do the accounting in the way California wants it. The trustees got to provide beneficiaries with regular accountings of the trust assets or have such accountings waived. So keeping the beneficiaries informed, keeping the property separate from other property. So you want to not just take all those assets and put them into your own personal account as trustee. Bad idea. That's commingling. You don't want to do that. It has to be separate. So have a bank account. Your name is trustee. If there's personal property, put it in boxes, identify it, mark it as the decedent's property. And designating property as trust property. So this, oftentimes with personal property, it's very common where mom might pass away and the kids have like a diploma or something at mom's house. That is really the kids' property. So that's segregated. Enforcing trust claims and defending actions against the trust. If the trust is owed money, maybe mom lent money on a deed of trust and you got to collect that money, right? And defend actions against the trust. If somebody sues the trust for something, you have a duty to defend. You have a duty not to delegate to others the performance, the acts that the trustee can reasonably be required to perform personally, signing a tax return, those type of things. And when there are two trustees, you have a duty to keep your other trustee from breaching the trust. So if you know your co-trustee is going to the ATM and taking cash out, by the way, that is probably the worst thing that you can do as a trustee is go to an ATM and take cash out. Bad idea. You have a duty to, frankly, to stop that. And you have a duty to apply the full extent of your skills. So if you have skills, you have a duty to apply those. So if you happen to be a CPA, you can't just throw your hands up and say, well, I'm not going to apply my CPA skills. You got to apply them. Trustees have to account. So you can think of an accounting, if you're the trustee, you can think of an accounting as, kind of a bank statement. It's like, a date of death has a certain amount of money. This amount of money came in, this amount of money went out. This is what's left over. All those have to add up. That's an accounting, okay? If those numbers don't add up, the trustee is 100% personally liable, meaning the beneficiaries can get an order because that court has jurisdiction over the trustee and get an order saying, hey, trustee, you need to make the beneficiaries whole. You're going to pay out of your pocket. Again, don't withdraw cash from the trust checking account. Literally the worst thing that you can do. I have heard many a bench officer judge say, you took cash out. Like it's one of those unbelievable things. Just don't do it. All right. Really think about having an interest-bearing checking account. Interest rates are up. I would think if I'm a judge and I've sat as a judge pro tem in probate, I would be looking at this and saying, why are you not getting any interest on this $100,000? Because you could be getting 4%, right? Or whatever it is, 5%. And a separate checkbook register. That's kind of makes sense. It's easier with technology. Balancing the account monthly, very important. Don't just never balance it or balance it, at the end. And then maintain careful records of all transactions. How do you educate your trustees? Go to our website. We've got plenty of content on our website. I'd really encourage you to take a look at that. And we also have Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer, which is a book that I wrote, which is really a primer for doing estate planning. So if you're thinking about the estate planning process and I'm wondering, how are these people going to get paid? Take a look at that book. It really kind of goes through all the questions that a savvy lawyer, a knowledgeable lawyer is going to ask you about your estate plan. Okay. And if they don't ask those questions, probably not the right lawyer. You might want to keep looking. And then how do you educate your trustee? Give them resources. We've got a newsletter. We've got certainly our YouTube page. We've got tons of content on our YouTube page. And if you haven't visited there, I'd really encourage you to take a look at it. Our offices are located in Northern and Southern California. I happen to be in one of our Southern California locations today. And it's September 14th coming up next week. 5 ways to put assets in a living trust. This is funding your trust. If you have a living trust, I really encourage you to take a look at this. If you're thinking about a living trust, if you know someone who has a living trust, funding your living trust, having a properly funded living trust is a great way to stay out of probate court. How many people have a trust, put the house in when interest rates were low? Boy, weren't those great times. You refinance the property. What they do, they made you take the property out of the trust. Well, you got to put it back in. Otherwise, your trust isn't fully funded. So that's one of the things we're going to talk about. And if you can go ahead and there is a link in the description, a link in the chat. And if you're looking at this on YouTube, there's a link in the notes to take you to that video. Subscribe to our YouTube channel, click the little bell, and you will be alerted to our latest content. And we will open it up for questions. We're doing this live. If you're watching this on YouTube, keep watching, because the next video is just going to magically roll right up.